Thank you very much. It's a pleasure to be here, not only because I am part of the Transitional Justice Center, but also because it's an honor to be asked to speak to all of you. Over the past 20 years, modern international criminal justice institutions like the International Criminal Court, the International Criminal Tribunals for the former Yugoslavia and Rwanda, the Special Court for Sierra Leone, and the extraordinary chambers in the courts of Cambodia have contributed to the rapid development of international criminal law. And by this I mean the development of genocide, war crimes, and crimes against humanity law. And I've been involved in the field of international criminal law for over 20 years now. Perhaps I shouldn't admit that, but I have, since the founding of the International Criminal Tribunal for the former Yugoslavia, or ICTY, in 1993. So I have witnessed a vast change in the field as it relates to gender-based crimes. And I'm going to outline 4 different eras, if I can put it that way, which are not mutually exclusive, which do overlap in how gender, and specifically sexual and gender-based violence, has been conceived in international criminal law and by international criminal tribunals. And the 4 eras are, first, the recognition of rape, that rape is a crime, and that rape is a war crime and a crime against humanity in particular. So that's the first era. The second era is a recognition that there's sexual violence that is not rape, that there's something beyond rape. The third era is a recognition that, wait a minute, all of this is part of gender-based crimes. So the discussion of sexual violence was also often equated as being the exact same thing as gender-based crimes. But there came a recognition that, wait a minute, gender-based crimes are even wider than sexual violence crimes. And the fourth era is a recognition that women, girls, boys, and men can all be victims of sexual and gender-based violence. And I know that probably to you that sounds very obvious, but it wasn't obvious in international criminal law for quite some time. So I'm going to go through each of these 4 eras. The first era dates back to prior to 1993, and that is the recognition of rape as a crime, and specifically as a crime against humanity and as a war crime. So it wasn't that long ago that there was questioning as to whether or not rape was an international crime in conflict or in genocide. And that questioning came about, or the height of it came when the Security Council, the United Nations Security Council, was considering what to do in the context of the Balkan Wars. This was around the time, 1990, 1991, 1992, 1993, when there were reports coming out of the Balkans of what were called rape camps. So camps where women and girls were being held and raped, and some being forcibly impregnated. So these reports were coming out, and as the number of reports were growing in the media over time, the discussion grew in the international legal field over time as to whether or not rape would be an international crime. And it's rather shocking to think today that there would be even any question about this, but there was some question at the time. And interestingly, that question was settled in the affirmative that indeed rape is an international crime in 2 different ways. One of which was a very well-known international law professor by the name of Theodore Meron. And if any of you follow the tribunals, you'll know that he is now the president of one of the international tribunals. But at the time he was a law professor, he came out in a very influential journal and said, of course it's a crime. And why I find this interesting is because it took a man, a very senior man, to say this. And then it was considered rather settled, even though at the same time there are very many feminist authors who were making the same claims. But once he did that, it was considered rather settled in international criminal law, at least on the academic side. On the policy side, it was settled at the 1993 World Conference on Human Rights, the United Nations World Conference on Human Rights, where this was discussed and affirmatively acknowledged that rape is an international crime, crime against humanity, and a war crime. Then that was taken up by the UN Security Council in creating the International Criminal Tribunal for the former Yugoslavia, listed rape as a crime against humanity. And then again the next year, where rape was listed in the Rwanda Tribunal statute as a war crime in internal armed conflict and as a crime against humanity. And then again in the jurisprudence of the International Tribunal. So the title of my talk is International Criminal Justice, Grappling with Gender, Mistakes, and Progress. And I've already talked now about the progress on recognizing rape as an international crime. But here is where we also have the grappling part. There have been 4 different definitions put forward of rape in international criminal law. And I can't say that any of them have taken absolute precedence so that we only really have one now. We still have more than one definition of rape. And I think that's problematic. I mean, if we're going to have an international crime, we should have a settled definition of what rape is. But the heart of the debate on the definition of rape stems from problems at the domestic level and how much to import the domestic definitions of rape into the international. So the first tribunal to define rape decided that we should not take the domestic definitions of rape at all. And they created, the tribunal created a brand new definition of rape under international criminal law. But subsequent tribunals relied much more heavily on domestic definitions of rape. And for those of you who have studied domestic rape issues, you would know that the issue of proving consent tends to be very contested at the domestic level. And in some countries, it's very, very contested in that there are very narrow circumstances in which a woman can, and it has to be, in some places, it's the victim who has to prove that she did not consent. And then in other places, there are wider rules of procedure. For example, in Canada, it's not even called rape in Canada, it falls under sexual assault. And there, the issue of consent is dealt with in a broader manner. But the problem was that the tribunals imported all of these domestic definitions, but without addressing the fact that it's contested at the domestic level how to deal with this consent issue. So, of the 4 different definitions, we have some that have a requirement that the prosecutor must prove beyond a reasonable doubt that the victim did not consent to the sexual attack. And then we have others that don't have the requirement of proof beyond a reasonable doubt of the lack of consent because of the context in which these sexual attacks had occurred, namely armed conflict, massive oppression, and various other types of crimes going on at the same time. And this is not yet resolved in international criminal law. So moving to my second era, the recognition that there are sexual crimes beyond rape. For a long time, because rape was the only crime listed in the ICTY, the Yugoslav and Rwanda statutes, it was the crime through which all of the gender-based issues were funneled. So when the prosecutor charged rape, actually evidence came out of other types of gender-based crimes, but they were mediated through this definition of rape or the discussion of rape. And this was viewed as a problem because it's really important in law to name crimes. In doing that, by naming something as a crime, you give legitimacy to the fact that that is illegal. That particular act is illegal. So during the years leading up to the creation of the International Criminal Court, there was a lot of lobbying going on by women's groups, by activists, by human rights advocates, saying we need to name other types of sexual violence so we can have a broader recognition of what is actually happening in conflict. And that happened in the Rome Statute of the International Criminal Court, where sexual slavery, enforced prostitution, and any other form of sexual violence of comparable gravity, so that's a very broad category to capture new types of horrendous sexual violence that are created by perpetrators, both as crimes against humanity and as war crimes in internal and international armed conflict. So that's the progress side. And there has been progress also in judgments. So for example, the Special Court for Sierra Leone has had very extensive jurisprudence on sexual slavery in armed conflict and has set out the legal elements of crime, the context in which this occurs, why this occurred in that particular conflict, and who the victims were. And also on a positive note, the International Criminal Court made a very progressive finding in a recent decision in the case of Bosco Ntaganda, who was a commander of a feared militia group in the Democratic Republic of the Congo. Ntaganda is charged with several counts of war crimes and crimes against humanity, and he actually turned himself over to the International Criminal Court, much to the surprise of the International Criminal Court, by showing up at a US embassy in Rwanda and asking to be sent to the International Criminal Court in March of 2013. So the ICC has had a confirmation of charges hearing in his case, and that's one of the steps in the procedures at the International Criminal Court. And in that hearing, the prosecution alleged that he is guilty of attacks on civilian populations, including attacks that gathered up child soldiers and then subjected those child soldiers, and in particular girls, to sexual violence by their own compatriots. So within the child soldier population and the commander population and soldier population of his militia group, that the girl soldiers were subjected to sexual violence, in particular rape and sexual slavery. So in making those arguments, for those of you who know international humanitarian law, and I don't know if anyone else does other than Kirsten, but under international humanitarian law, it's very important to determine whether someone is a fighter or not a fighter, because there are different protections that apply whether you're a fighter or not a fighter. So the prosecutor had to make an argument that the girls, when they were subjected to sexual violence and sexual slavery, were not fighters at those times, and therefore had protection under international law, and therefore that the prosecutor could charge Ntaganda with these crimes. And the defense said, no, you can't do that. He's not responsible because these were fighters, these girl soldiers were fighters, and too bad what happened to them. The pretrial chamber of the International Criminal Court agreed with the prosecutor, and this was one of the very first times in international law that sexual violence directed by one's own compatriots against their own group has been recognized as a crime in international humanitarian law. So let me go to the third category that I mentioned, and that is the recognition. So we started with rape is crime, then we started with sexual violence is crime, and now we're going larger. Gender-based crimes. Gender-based crimes include crimes of sexual violence, but they are not necessarily only crimes of sexual violence. At the time the International Criminal Court statute was drafted in 1998, there was a recognition that there were gender-based crimes apart from sexual violence crimes. And so that statute includes forced pregnancy, enforced sterilization, and gender-based persecution. Now, none of these have actually been litigated by international criminal tribunals, so we don't have a lot of knowledge as to when they might apply and whatnot. But another type of gender-based crime has been extensively litigated, and that is forced marriage. It's been litigated in two different tribunals, the Special Court for Sierra Leone and ongoing in the extraordinary chambers in the courts of Cambodia, or Cambodia Tribunal. So what is forced marriage? Forced marriage is described by the Special Court for Sierra Leone in this way. In that conflict, girls and women were often captured or abducted as civilians, and then they were forcibly assigned as so-called wives, and I use wives in quotation marks because they weren't actually wives, but they were called wives, to rebel commanders and soldiers. And these wives were expected to carry out whatever their so-called husbands wanted to do. So often that included forced sexual intercourse, rape. But it also included things like cooking, cleaning, childbearing, child rearing, gathering up all the husband's belongings, carrying them to the next camp, etc. And sometimes even protecting them. But the lives of these so-called wives were punctuated by extreme violence. And if you think about it, you can think of it as the war of Sierra Leone coming into the bodies of these women, because the war was brought directly home and directly personal into their bodies. The Special Court for Sierra Leone statute does not list forced marriage as a crime. And here we get to that point that I made about naming something, the importance in law of naming something so as to make it clear that it is illegal. So the prosecutor had to figure out how he was going to prosecute this. So he called it inhumane acts, which is one of the categories under crimes against humanity. And this led to a lot of debate as to whether or not he could do this. I mentioned in the beginning that part of the title of my talk has to do with progress and setbacks. So I'm going to start with the setback in this. And that is that the prosecutor presented what happened in the conflict, which everyone in Sierra Leone calls bush marriages or bush wives, to the court. And the court said, that is exactly the same as sexual slavery. We don't think there's any difference. We're going to dismiss the charges for forced marriage. And that was a big setback, because what the court did in saying that, and I should say it's a majority of the court, there was one very strong dissent by a feminist judge who recognized that this is a gender-based crime. But what the other two judges did by dismissing the charges was shrink what is a gender-based crime. So in other words, the socially constructed norm that these girls and women were going to be so-called wives, cook, clean, have babies, look after them, be ready for sexual intercourse whenever, and captured it only under sexual slavery, which is a sexual crime. So they ignored all that other stuff. They ignored the forced cooking, the forced cleaning, the carrying, the farming, etc. Thankfully, the appeals chamber overturned this and said, you can't do that. You can't ignore a whole bunch of the stuff that happened in a crime and misname it as something else. And then it was further developed in future judgments. So the Revolutionary United Front judgment is one of the signatory judgments of the Special Court for Sierra Leone, because it had to do with one of the main rebel groups. All of you have surely heard of, the one that cut off hands and whatnot. The one that was in the movie Blood Diamond. So the trial chamber in the RUF case said, we need to think of this even broader than what the appeals chamber told us to think of it as. We need to think of this in the larger context of what happened in the Sierra Leone conflict in the 1990s. We need to see how the forced marriages actually facilitated the takeover of civilians by this rebel group. That is what I mean by the third era of looking at gender-based violence. What is the role of gender in the overall conflict? And what they found was that the Revolutionary United Front consciously chose the word wife, bush wife, to denigrate the girls and women who were captured. It was deliberate and strategic so they could be psychologically manipulated, and at the same time they could have two things achieved. First of all, they get free domestic and sexual services to members of their militia group. Secondly, they can demonstrate their control over all the civilians in their area. When it came time for the final case of the Special Court for Sierra Leone, there was some dispute over this term forced marriage. And the judges in that case addressed the issue, even though Charles Taylor, the former president of Liberia, was not actually charged with forced marriage. They disagreed and said, we don't like this term forced marriage because there's no actual marriage taking place. It's a misnomer. It's a word that doesn't fit. There's no legal ceremony, which is what is usually required in countries for actual marriage. They said, we need to call this conjugal slavery. It's a combination of sexual slavery and forced domestic labor together. And this is interesting and I think helpful, because what happened to bushwives was indeed slavery. I think we need to think a little bit more about whether conjugal is the right word, because that's still linked to marriage and it has very different meanings, some not so great for women and girls all around the world. So I think more legal thought needs to be given to that. Let me turn to the Cambodia Tribunal, which is also charged forced marriage in very different circumstances than the Special Court for Sierra Leone. And this goes to show that legal definitions need to have flexibility in them. But it also shows that we need to give some more thought as to what forced marriage actually is. Because the extraordinary chambers in the courts of Cambodia are looking at, in two cases, case number 2 and case number 4, a practice that occurred in Cambodia during the Khmer Rouge regime, where the Khmer Rouge would round up numbers of women and men, or girls and boys, some of them were under 18, and just forcibly marry each other. They didn't know each other, and sometimes it would be mass marriages. They would gather together 30, 50, and just force them to marry each other, with the idea that they needed to procreate to create the ideal Khmer Rouge citizen. The babies would, in essence, be these ideal citizens of the new future under the Khmer Rouge. Part of that, of course, included rape, because the forced procreation was between two non-consenting individuals who were forced to have sex with each other in order to procreate. So here you have male and female victims. It's a different scenario than in the Special Court for Sierra Leone. And it's a different type of scenario because actual marriage ceremonies did take place under the laws of the Khmer Rouge. They were different than the laws of Cambodia that existed prior, but there were legal mechanisms in place to make these marriages legally legitimate, at least at that time. So it's a different scenario. The Cambodia Tribunal has not yet sort of delved into how to define this particular crime, but it's coming in its cases. I want to, before moving to my final era, mention something that has been happening in international criminal law that's related to the issue of understanding gender, that is very worrisome on the one hand, but there's also progress on the other hand. And that is the issue of foreseeability of crimes of sexual violence within armed conflict. And I turn first to a new case, a new judgment at the International Criminal Court, or relatively new, it happened last March, in the Katanga case. In that particular case, the accused, Katanga, was a commander of the militia in the Democratic Republic of Congo, and he was accused of murder, rape, sexual slavery as crimes against humanity, and a number of war crimes, including sexual slavery and rape. He was found guilty by the trial chamber as an accessory to the crime against humanity of murder and the war crimes of murder, attacking a civilian population, destruction of property, and pillaging. And what's not in here is rape and sexual slavery. He was acquitted of rape and sexual slavery. Why? Because the trial chamber did not think that it was foreseeable that when he supplied the militia with weapons to carry out an attack, that rape or sexual slavery would occur during or as a result of that attack. And I find that, for one, very worrisome. Because why should different analyses take place when evaluating murder or pillaging than for rape or sexual slavery? Why are different questions being asked within the International Criminal Court about foreseeability of these crimes, for the sexual violence crimes and for the non-sexual violence crimes? And this hasn't only been noted by me, it's been noted by a number of individuals, including Bridget Inder of the Women's Initiatives for Gender Justice, which is one of the leading NGOs focused on the International Criminal Court. And it's not the first time that this sort of differentiated analysis has taken place. This has happened at the International Criminal Tribunal for the former Yugoslavia, in the Sejnovic case and the Đorđević case, and also in the International Criminal Tribunal for Rwanda. That said, there is progress in that the initial findings by the trial chambers of lack of foreseeability in an armed conflict of rape and sexual slavery, just rape, they don't have sexual slavery as a crime, were overturned by the appeals chamber in the Yugoslav War Crimes Tribunal. So let me turn to my final era. And that is the recognition that women, girls, boys, and men are victims of sexual and gender-based violence. So for some time in international criminal law, it was largely assumed that the victims, the sole victims of sexual violence, were girls and women. And if you think about it, or at least if I think about it, I can understand why this was. It was because when we started back in 1990, 1991, 1993, there was no recognition, virtually, that sexual violence, let alone gender-based violence, took place during armed conflict. There was no legal recognition in international criminal tribunals and even domestic criminal tribunals looking at war-related acts. It took a lot of effort on the part of a number of women's rights activists and human rights activists around the world to drag the issue up through the levels of the United Nations and other places to the top to show that it's taking place and that attention should be paid. And so these women's rights activists were dragging out the previously hidden violence that occurred against girls and women. And that was a big, big success in terms of getting recognition. And over time, the United Nations and others became accustomed to finally investigating these sorts of crimes, to getting best practices in investigating these sorts of crimes, and to talking about these crimes in the international arena. And then there were, of course, jurisprudence, judgments of these international criminal tribunals on women and girls. But it was the International Criminal Tribunal for the former Yugoslavia that then highlighted, well, wait a minute, men and boys are also subjected to this as well. And we don't know the numbers. Many people say that the numbers are vastly different between men and boys and women and girls as victims of sexual and gender-based violence. We don't actually have reliable numbers at the moment. But the Yugoslav War Crimes Tribunal started bringing on these cases about men and boys held in detention. And what was coming out in the evidence was that these men and boys, many of them, were being subjected to forced intercourse amongst each other by guards and others in command for entertainment, or as punishment, or as forms of torture, and also subjected to sexualized torture by guards and commanders. And this recognition has built up over time, such that now that we have UN international commissions of inquiry in Libya and Syria, it's now standard practice to examine whether or not sexual violence is occurring and gender-based violence against women, girls, men, and boys. And quite a bit of evidence has come out from the Syria and Libya independent commissions of inquiry that there are different forms of sexualized torture being used against men, and used men and boys, and using women and girls, and some same types of sexual violence used against all. There have been some setbacks in this progress, however, and I'll mention that, and then I'll close. The setback that I want to refer to here is in the Kenyan case at the International Criminal Court. In one of the Kenya cases, the prosecutor wished to charge the crime against humanity and other forms of sexual violence in relation to the forced circumcision of Luo men during the post-election violence in Kenya in 2007 and 2008. The pre-trial chamber, looked at this and disagreed with the prosecutor that this could be categorized as a crime of sexual violence. They said it's more properly listed under the crime against humanity of inhumane acts, without a whole lot of explanation. So at the next stage of proceedings, the prosecutor brought the same argument and said, I'm categorizing what happened to these Luo men in forced circumcision as sexual violence. And the pretrial chamber then came out and was more specific and said, no, we do not agree with you that this is a form of sexual violence. they categorized the targeting of the Luo men for forced circumcision and penile amputation as part of an ethnic form of revenge. The prosecutor made the argument that it may be an ethnic form of revenge, but it's an ethnic form of revenge with a sexualized aspect to it. The reason why forced circumcision was being directed against the Luo men was because it was meant to target the gender-based understanding that without their foreskin or their penis, that these men were no longer virile. They could no longer be leaders in their community. And that was why the prosecutor called it sexual violence. The pretrial chamber disagreed once again and said, first of all, something that was a bit confusing, because they said, we understand the prosecutor's argument to be that an act of violence is sexual if it targets sexual organs. That's not what the prosecutor was saying. The prosecutor was saying that it's rooted in larger gender understandings of what circumcision meant to Luo men. But anyway, that's what the pretrial chamber said, and therefore they recategorized it once again as inhumane acts. So what they're doing in this circumstance is taking it out of the gender discussion and putting it into so-called gender-neutral discussion, right? This is a bodily harm as opposed to a sexualized harm. So that's one of the setbacks that I referred to. So in conclusion, where are we at today, given these four eras that we have gone through and still are in, especially this the third and the fourth eras, we still are. Where does that leave international criminal law today on sexual and gender-based crimes? Well, I think we've come quite far, but I still think we have far to go. The reason why I think we've come quite far is because the Office of the Prosecutor of the International Criminal Court in June released a policy paper on sexual and gender-based violence. And if you read it, and I highly recommend it if you're interested in this area, you do, it's very, very progressive. It has a really deep understanding of what gender is. It has a very deep understanding of what gender-based crimes might be. Not only rape, but it does include rape, that the victims may be anybody, that gender can explain why certain people are targeted in the way that they are. But the policy also says the prosecutor's office, prosecutors and the investigators within the office have to approach every single investigation with this deep understanding of what gender is. And in doing so, they will uncover more forms of harm than they have in the past. To be honest, they haven't had the best reputation on prosecuting gender-based crimes to date. By having this deep understanding of gender, the hope is that going forward, we've gone from understanding rape to understanding sexual violence to understanding gender to understanding victims. Hopefully we'll take it quite a bit further to understand how gender informs every crime. Every single crime has a gender aspect to it. Maybe a minor aspect, maybe a major aspect. But in this way, in the International Criminal Court at least, all prosecutors, all investigators should, in theory, be able to understand that larger context that is so necessary for a proper understanding of crime in international criminal law. And I'll end there.